hearing. We are now recording, and I'll, if I could, I'll ask the trustees in attendance and staff to introduce themselves. There is no need for a quorum of the board for this meeting, as it is statutorily required public hearing. But still, I would like the record to reflect those of us who are here, and then I will make some introductory comments and hand it over to Ms. Wilson for her piece of the program. Good morning. My name is Ruben Duran. I'm the chair of the State Bar Board of Trustees. If I could ask my fellow colleagues from the board to introduce themselves. Mr. Tony.
I'm Mark Tony. I serve as a Board of Trustees for the State Bar.
Thank you. Mr. Stallings.
All right, and good morning, everyone. My name is Brandon Stallings. I'm the Vice Chair of the Board of Trustees and a Supreme Court appointee to this body.
Thank you. Ms. Wilson, would you like to introduce yourself and your staff?
Sure. Leah Wilson, the Executive Director of the State Bar. Louisa.
Good morning. My name is Louisa Aripetian, and I'm the Board Secretary.
And good morning, everyone, as well. My name is Alfredo Hernandez. I am a Program Analyst in the Office of the Executive Director.
Wonderful. Thank you, everyone. So this hearing is being held under the authority and as required by Business and Professions Code 6095 subsection A. We do this at least twice a year to give members of the public and our licensees the opportunity to offer their thoughts and their comments on our disciplinary procedures, the attorney competency programs that we run, and our admissions procedures as well. Ms. Wilson, I may have taken your full introduction, but I will hand it to you in case you have a few other items to add.
No, I don't. We're just looking forward to hearing what our attendees have to share with us.
Okay, with that, we're going to get right into it. I see that one attendee has raised their hand. We are going to try out a new technological function here, and that is a visible timer so that folks who are speaking and everyone else attending and observing and see the time limit. We generally keep our public comments to 3 minutes, just to make sure that everyone has an opportunity to provide input. We do welcome your input. We thank you for being here this morning to either participate or observe. And with that, I see that our first person raising their hand is NC Carlson. Mr. or Ms. Carlson, once your microphone is activated, you'll have 3 minutes, and we look forward to hearing from you. There you go.
Okay, can you hear me?
We can, yes.
Okay, terrific. Last time we had a lot of technical problems. Good morning. Thank you for the panel and thank you for your hard work. I've been attending all the meetings and I know this has been an arduous task. So in brief, I had a list of items and I want to try and stay in the 3 minutes. I really appreciated Richard Zittrain's report because I really thought it was the singular report that kind of had an edge to considering the complainants or the victims in this, where his view was that we needed to pay more attention to what the public comment is. I noticed in the focus groups, I'm stream of conscious here right now. I noticed in the focus groups there were nine members of the public. I probably was one of them. I have to tell you, I've become intelligent about perusing the State Bar website in its complex, and it's not user-friendly really for the public, even when it says public. And so I think that's something that has to be addressed, because I feel that with the amount of negativity that we had with the State Bar's results in the audits, that it was really imperative to have a press release that went in, I hate to say it, but in the public media, that would have prompted the media to say, hey, listen, they're going to be reviewing things with the State Bar and the public's invited. And then people from the public would say, oh, gee, there's certainly been a lot of people who've been through the State Bar system. And if you ask them, they all turn up their nose and say, it's a waste of time. I just got frustrated and I ceased doing business with us. And this is a serious entity that operates with really the equivalent of the Department of Justice authority in protecting the public and dealing with people who we pay a lot of money to and are seeking legal advice. And when they err, whether it's intentional, willful, or by omission, the public needs to have some sense of where do I go with this? And the state bar has, as your commission knows, would file a complaint with the state bar. And what was striking to me was I've actually formed an entity called the Consumer Bar, which was meant to be like oversight relative to public input on it. So having said that, I've filed some complex complaints with high profile attorneys. And these cases were assigned to investigators with less than 6 months experience, and then immediately closed the case. And when there were volumes of documents, and including other corroborating attorneys who were never contacted relative to this, and where there were prior convictions, prior Superior Court and even Supreme Court findings of unethical conduct and misconduct. So if you ever had a case presented to you where there was complex case and high profile attorneys, whatever is going on in intake, and that's why I'm raising this question, when you're talking about in your report how things are handled in intake, when you got to designate a complex case,
Sorry, your time is up.
well, I think what I have to say is somewhat important. And so I beg a brief extension for another
Ms.
minute.
Carlson, we'll let you go for another minute or so if you could
Thank
wrap it
you,
up in that
because I
minute,
do
that'd be
think
great.
this is important. Second, having been in that circumstance or seeing this happen, and having the attorneys who are named as corroborating attorneys relative to the complex case say no one ever contacted me was really kind of stunning. Now let's take it for the next step. Now in the investigation process, the state bar has closed the case, and hopefully you guys are remedying what the intake, prosecution, and evaluation of cases are inside. And I'm in sympathy that a complex case takes a long time, and that you need to find perhaps the right people for certain things. But I will also say it's not appropriate to get back to a victim and say, well, you know, it's a high profile attorney and it's a professional litigator. You know, they're just going to bury us in paperwork. So we're just going to shut the door on this and walk away. Now, having said that, what does the complainant do? They say, well, where do I go to appeal this? You don't find any information really on the state bar website about that. And the public doesn't know what to do. And you get a form letter that says, go to the complaint review unit. Try and get through the complaint review unit. It's almost impossible. You email them and you say, what's the procedure to do it? And they don't really provide you a procedure. So I would like you to address the full scope of filing a complaint with the state bar procedurally into the OCTC and then over to the OGC and basically the CRU. And I even asked them, do you want it on pleading paper? Do you need a summary of this? Well, not really. You know, we can just get the documents. Do you have all the documents? Can you confirm that the OCT has provided all the documents? And then finally, my last point is, during all of this, the complaints, whether simple or complex, there's the view from the public is there is no status report whatsoever. You never hear from anybody. It's frankly, you get a form letter from an investigator and typically you don't really hear from them. Your report may say that they contact them, but that's not necessarily the case.
Okay.
I hope that's helpful. My view is to be constructive in this practice.
Absolutely.
Okay.
No, I hear that, and I certainly do appreciate you taking the time to share your thoughts. They were, I think they were all very well put, and I'm sure that we're going to take note of it. And with that, we'll move on. If it's okay with,
if you don't mind, I know this is a little unusual, but this is a different kind of format. Ms. Carlson, I would love to get more information about the organization you said you started, the Consumer Bar.
Yes.
Yes.
I've actually registered it, not that they required a formality to it, but it's an outgrowth of actually me talking to various counsel who have filed complaints with the state bar or supported complaints of clients who have made complaints to the state bar or submitted cases that were in Superior Court where there were egregious findings everywhere from elder abuse to client trust account. And the state bar has the authority to act on its own. And the attorneys figured, well, we submit these cases to the state bar can act on its own, but nothing happened.
Okay, so my email is on our website. I don't know an easier way.
I know who you are. Yeah.
Okay, great.
I
Please
think
do
I've
reach out.
emailed you in the past.
Okay, please reach out and provide me with, a link or any information about the organization. I would appreciate it.
Right. So I do, summing up, I think that there's the website needs some improvement relative to that, but most fundamentally is that some clarification. You're going to have to deal with the internal mechanics of the staff and staffing and their qualifications on handling things, because it's not been great. But really, so that the view it from the public for a change. And I think the only person that did was different. Whereas if you were filing a complaint, what would be your expectations? You would file it, you'd expect to hear from someone. If they received information from the respondent, you would appreciate saying, here's what we've heard from the respondent, because you may have impeachment evidence. Remember, people in the public are filing it. They're not typically attorneys doing it on pleading paper and considering all the rules, laws, and statutes. So it's relatively important for the investigator to get back to the person, say, here's what we've heard, so that there isn't, well, we'll just send a form letter off and you go to the complaint review unit and you're starting from scratch. That is why I think many people from the public are very dissatisfied, and attorneys themselves will make jokes about the state bar not processing cases.
Okay, thank you, Ms.
Okay.
Carlson. Appreciate it.
Thank you, Ms.
That's-
Carlson.
I hope that.
Very helpful, certainly. And I do encourage you to reach out to Ms. Wilson with the information about your organization. Mr. Hernandez, if you would do me the favor of setting the timer to 5 minutes per speaker. Certainly, this is the appointed time to receive this sort of input, and we welcome it. Our next speaker is Zoom user. So Mr. or Ms. User, when your microphone is activated, you'll have up to 5 minutes to provide your comments. Welcome. Good morning.
Hi, good morning. I'm just chiming in to request that the bar renew the COVID provisional licensure program. I'm an attorney who met the requirements for that program with adequate bar scores between, I think it was 2015 and 2019. I'm licensed in New Mexico, and I was even enrolled for the bar exam again in 2020, but could not take it due to requiring bilateral hip replacements. And I recently received a survey from the state bar inquiring as to why I did not apply for that program. And that was on October 3rd. And that was the first notice that I had received of my eligibility for the program. And so I mean, I saw that the application period had expired, but I've been working as a federal attorney in California and under the supervisions of California attorneys here. And so I could have easily met the requirements of that program, or even I called the admissions office and requested, or asked about the possibility of a retroactivity for that program admission. And they told me that it expired and that basically the bar was going to write to the Supreme Court recommending either to end or extend the program or renew it. And I think that she informed me that there were several other people in the same position as me who had received this notice, but not been notified individually as to their entitlement to apply for that program. And although there were others who were notified in person, and that I should have just, but her answer was very unsatisfactory, because she said, I should have just been following the state bar website and or social media, which as a non-member of the California bar, it's not really something that I would do. So to me, I mean, it just raises questions of equity, as far as basically, to me, it appears that only insiders of the California, legal community, people who may have been working or having an internship at a California firm, would have had any notification of this program. And also because some people were notified and other people were not, it raises issues of, basically individuals in my situation were deprived of a due process for a substantial economic interest. And so had I known, I definitely would have applied because it would have been so easy for me to do it. But now it's, I just get this message that, if you snooze, you lose, and I had no notice. So that's all I have to request.
Thank you. Thank you for your comments and observations. Let me just check to see with Ms. Wilson, is there something additional we can refer this gentleman to, another resource either on the website or otherwise? I don't believe we got a name, so I don't know how we can communicate directly.
No, but what I will say is on the board's agenda next week, a week from today, in fact, the provisional licensure program will be on the agenda, and staff will be making recommendations for the board's consideration regarding a number of issues, including this one, those who were not noticed during the original communication about the availability of the program. So I'd encourage the participant to, I'm sorry to say, but go to our website. If you go to the website and email me, we can make sure to affirmatively reach out to you. But if not, look for the materials that will be posted for the board's meeting.
Yes. What is your name?
My name is Leah Wilson, and I can give you my email now. I just don't want to take up too much time, but it's Leah, leah.wilson@calbar.ca.gov.
Leah T. Wilson at CalBar.
Leah T.
Okay,
Yeah.
Yeah, I'll go to the website and check. I mean, I couldn't really find significant resources on the program because I tried to go back to my admission site, because I took the bar 3 times and did not pass, but my scores were all, enough for this program. And I tried to, just see if I could go to the admissions portal and start an application for the PLP, but I was unable. It was just really upsetting to have no notice that the program even existed and that I was eligible until the bar sent me a survey asking, hey, why didn't you participate in this program that you were eligible for? Because the fact that the bar sent it to me shows me that the bar clearly had the capacity to identify eligible individuals and notify them. So it just seemed, it was just a really kind of upsetting gotcha moment to me.
No, and I think I can safely say we hear and appreciate the frustration, and the agenda item that's on our agenda for next week is meant as a way to try and address that. And you are certainly not alone in your circumstance. I appreciate you taking the time to reach out to us.
The admissions office definitely made it clear that I was not alone.
Yeah. So no, thank you for letting us know, and certainly whether or not you join us next week, I think those of us on the Zoom here are certainly going to have you in mind as we're considering that item. I would encourage you to take a look at the agenda item and the materials once they get posted, which I anticipate probably will be early next week.
But that's also a public hearing.
That's right. All of our meetings are public meetings. Yeah.
Okay, great. I'll look into that and hopefully talk to you next week. Thank you.
Wonderful. All right. Thank you so much for joining us. Next, we have Benjamin Cohn. You'll have 5 minutes once your microphone is activated. Thank you. Thank you for joining us.
Thank you. I am calling on or speaking on the admission rules side, there is a rules revision proposal coming before you at your next meeting pertaining to testing accommodations. And that rules revision proposal is part of a larger package the Office of Admissions has created, some of which they claim does not involve rules revisions, just changes to policies that staff have discretion and control over. The testing accommodation stakeholder forums that they said they based these changes on were largely guided by the policy changes they circulated, not the rules revision changes they made. The policy changes are the part of the proposal that benefits disabled applicants. It doesn't fix all of the critical components that were outlined by the DOJ and DFEH in their best practices report, but it does move in that direction. I think it should stand and then be expanded upon, but that's not what's coming before you next week. The rules revision proposal was never circulated for public comment at a stakeholder forum. It is being instead proposed under cover of these other proposed reforms. Every change to the rules revision proposal is detrimental to disabled applicants, but being listed on the basis of actually trying to respond to pretty much unanimous negative feedback from disabled applicants and the disability rights community. I pointed out in written comment to the CBE very specific concerns with the effects of these rules, but for years now, I have been making public comment asking for rules revisions on testing accommodations because the status quo rules facially violate the ADA and are discriminatory. Instead of doing that, they're making them even worse. And the written comments that I submitted to CBE outlines exactly why and how they are worse. I can't reiterate it in 5 minutes, but I'm happy if people want to discuss live to do it if given more time than that. I'll highlight first and foremost that the worst part is that applicants who don't petition months earlier than the deadline will not be guaranteed a decision before the next scheduled administration of the bar exam. Staff saying that they don't think that will happen doesn't change the fact that applicants should be guaranteed that a decision in time to prepare for equal opportunity, which the current rules don't do, but especially at least a decision before the bar exam, which this eliminates. Second, it eliminates CBE oversight over staff, well, not oversight, appellate review as of right over staff decisions from the appeal process. So it's no longer panel review benefit, and there's no administrative recourse beyond the director of admissions. Thirdly, the change to require some pretty arbitrary restrictions on what is considered procedurally complete for review that is not about what puts the bar on notice of all the facts that would entitle an applicant to an accommodation, or puts time limits on the admissibility of evidence. These rule revisions, it may seem like putting them out for public comment is a pretty innocuous step. You can address these things later in response to that. But because the status quo is so bad already, and this is your main opportunity to revise the rules in this area, that delay is unwarranted. It will mean it won't apply to as soon of an exam cycle as it otherwise would if you got the ball rolling on the correct reforms, which I've sent in written comment proposals of many times in the past, and not spent the 60 days and other procedural timeframe to revise the rules on something that should never be adopted, even if you reject it later. So I ask you to please put a revised proposal out as soon as possible that fixes those things, but reject the circulation of this proposal as is for public comment at your next meeting. Thank you.
Thank you, Mr. Cohn. Next, we've got Tyler G. Tyler G, once your microphone is enabled, you'll have 5 minutes. Good morning.
Good morning. I would like to take this opportunity to thank the board for their hard work over the years, particularly with the fact that there's growing pressure from attorneys, applicants for admission to practice, and the public at large. I've worked in family law since March of 2018, and I am a provisionally licensed lawyer and have been since February of 2021. Like many provisionally licensed lawyers, I took the opportunity in lieu of taking the bar exam in 2021 because I needed to enter the workforce right away in order to provide for my growing family. I'm a disabled veteran. I'm a non-traditional and first-generation law student, a father of differently abled children, and someone who cares deeply for my clients. The program has been an absolute blessing. Never before have recent graduates who have not yet taken or passed the bar exam been given the opportunity to represent clients within the full scope of their practice areas. I have completed a full dissolution trial and successfully represented dozens of clients over the last 2 years who may not have had access to the largest firm in my county where I work. That said, and I do not know if this body is aware of this fact or not, the bar exam results were leaked yesterday afternoon. I know that I did not pass the July 2022 bar exam. I also took and failed the February bar exam after a second read of my essays because I was within 50 points of passing. For February, I caught COVID-19 while studying. That derailed nearly a month of study time, and my youngest son, Atticus, was diagnosed with moderate autism during the first few weeks of February. Of course, I took up the cause and immediately sidelined my own studies to find him the resources that he needs and to get him enrolled in the San Andreas Regional Center. I understand that the way I manage my time and my life and my work are my responsibilities alone. At the same time, my life looks much the way that it does because I do care. I care about my family, I care about my community, and I am passionate about family law. I am trying to do everything that I can to provide for my family, to be the attorney my clients deserve, to be the associate the partners of my firm can rely on, and to meet the demands of the bar exam. And I'm coming up short, and I do not take the task lightly. The bar exam will be there, but my family is here now, and my clients are here now and in crisis. My family cannot hardly afford to have me take time off to study. And my clients cannot afford to lose their attorney, not just in the sense of a devastating disruption to their cases while it is moved to a fully licensed associate, but financially, because my rate has always been reduced. I will keep pushing forward with the bar exam, and I will keep trying because that is the only option right now. But after nearly 2 years of practice as a PLL, have I not proven myself beyond minimum competency? I took the recent survey that was released and felt cautiously optimistic after submitting the same. I would like to ask the board to consider further extending the original PLL program to give PLLs further opportunity to meet the requirements of admission to the State Bar of California. I am also asking that the board further consider expanding the program and providing a pathway to licensure for original PLLs. Thank you for your time, and thank you for the first extension. Whatever may come, this opportunity has certainly been a blessing for my clients and my family.
Tyler, I want to thank you for taking the time to talk to us this morning. Your journey and your story, I think, is a good example of a lot of the reasons why the Supreme Court and the State Bar wanted to establish the provisionally licensed lawyers program. You certainly raised a lot of issues, a lot of food for thought, but whatever happens, I want you to know that I certainly, as an individual, as a lawyer, as a chair of the state bar, appreciate your dedication to access to justice and to taking care of your family and your community. So I don't know that I have much to offer or add on the other issues you've raised. Certainly, if any member of the board or staff wants to chime in here, I'll ask them to do so.
I would just second what the chair has said. And there are a lot of, I don't want to say tricks, there are a lot of things that people can teach you about how to take the test. I don't know if you've availed yourself of some of that, but I believe that someone who is as dedicated as you are, putting that dedication towards the bar exam, if there's not something else that we can do quicker, you eventually you're going to hit it. I know that some people have a block. It's hard to take certain types of tests for some people. And that's always something I think we are all concerned with all the time. We, want to open up the testing and everything else in a way I think that is consumer friendly and that it really does test your knowledge about law. But if it's constantly preventing you from doing good work, then maybe we have to consider something else. And we're always looking at this. This is a very important issue, I think, not just for us, but for the Supreme Court as well. So thank you very much for your comments.
Thank you, Mr. Nolan. Mr. Duran.
Okay, we've got another hand raised. I want to make sure I get the last name correct. Josie Swanitz or Swanetz. Good morning and welcome. Thank you for joining us. Once your microphone's activated, we'll have 5 minutes.
I do not see Josie
Yeah, it
is
looks
on
like,
it. Oh, there. Okay, there we go.
there we go.
Yep.
Good morning, Ms. Swanetz. Your microphone is activated. We're looking forward to hearing from you. You may need to unmute yourself on your end. Looks like you might be having difficulty. We'll give it one more shot here.
Hello, can you hear me?
Now we can, yes. Thank you.
Okay,
Welcome.
perfect. Thank you so much. Hi, my name is Josie Swanetz. I am the Vice President South for the California Association of Black Lawyers. I wanted to raise my hand to address a letter that Cable sent back in March under the signature of our immediate past president, Eileen Casanave. We submitted it, and this was regards to the state bar's actions regarding attorney discipline and the state bar staff's decision not to implement all of Professor Christopher Robertson's recommendations in his July 16, 2020 report. We felt that the state bar staff did not go far enough to rectify some of the problems identified in Dr. Farkas's October 2019 empirical analysis. I just wanted to, part of my question is, I wasn't sure if you guys, one, received the letter, and two, if you were going to respond to the letter. The letter brought up a few things. I'll do a highlight since we only have 5 minutes of the main topics. Was the client trust fund account a recommendation that before attorneys are able to do a client CTA, that they take remote or in-person mandatory continuing legal education, so to have training to avoid those situations where there would be an overdraft or their account would be flagged. There are several states that currently do this, including the District of Columbia's rules of professional conduct require that. Another was addressing Professor Robertson's recommendation to raise the overdraft trigger. We also discussed, I know that the state bar staff did implement a 5-year closed complaint. However, those complaints could be opened based on the decision of a supervisor. And we just were asking for more information provided regarding, you know, how many cases have been closed, how many cases have been reopened based on such a request. What are the requirements or standards to be able to open a complaint? The next thing that we discussed was looking at an expungement of certain disciplinary records where after 5 years and there was no finding found and it did not proceed. Again, there are several state laws, even the ABA model rules for lawyer disciplinary actions or enforcement recommends an expungement of complaints and or dismissals within 3 years unless good cause is shown. And then the last thing we highlighted in our letter was legal representation for attorneys that are undergoing disciplinary actions. While we are all attorneys, this is this is not a practice area that many of us are versed in. And looking at either a pro bono or a sliding scale low bono representation arrangement, possibly with the private defense bar for this. So these were the this is just an overview of the highlights in the letter. I just wanted to address whether we would be having a response to the letter. Did you guys receive it? I can resend it, and really wanting to be able to have a meaningful discussion about our recommendations. And I'll give you a minute back in your life.
So if
Well,
I
I'm in corporate law. We all love getting time back.
I will second that motion. Actually, I appreciate that. But I certainly have this time.
Now I
dedicated.
can't hear you.
Not sure why. Can the folks on the
Right
Zoom
now, I
meeting
can hear you now.
Okay, good. I was probably not speaking loud enough. I was just making a joke about getting that minute back. I appreciate that. But this is certainly the time that we've set aside to hear your comments. I don't know. I certainly know who Cable is. I know that we have corresponded with Cable on various issues relatively recently. The letter you've described is not ringing a bell to me, but that just doesn't mean I haven't seen it. It could be some time since it's happened. Ms. Wilson, is there anything you have to add on that?
Yeah, I'm a little disappointed to hear this because we have had, I personally, as well as George, our chief trial counsel, has had several meetings with the Cable leadership, including with Ms. Casanave. The letter was circulated to the board some time ago. I recall a formal response, but we will look that up. And I know that in addition to sort of written response, there have, as I said, been a number of meetings to discuss the specifics of many of the issues raised, including the Client Trust Account Protection Program. At one point, there was going to be a small working group of the Cable leadership that was going to be tasked to work with us to address specifically some of the concerns. I have followed up with Cable, so there's been a lot of efforts to outreach and make connection, and certainly willing to continue to do so. I do know that we also have currently out for public comment the recommendations of the ad hoc commission on the discipline system, which address expungement. They address a pilot program for representation of attorneys in disciplinary proceedings, appointed representation. And we did send notice of those recommendations out for public comment, specifically to Cable and other affinity bars. So I will follow up on multiple fronts with this feedback, just looking for the original letter, sort of documenting what happened there, and then circling back around. If Josie, if you're the right person to do that with, I'd love to do that, because the intention is to partner on a number of these issues as we go forward.
I will say that we have definitely met with Ms. Wilson on several occasions regarding that, including talking about the client trust account. Our new president, Shamika Sikdu, I will definitely reach out to her regarding that small working group for the client trust account. Leah, I do have your email address. If you would like, I can get the copy that we sent and re-email it to you. I know that you were CC'd on it, Professor Robertson, which is probably why you remember receiving it. And Mr. Duran, the chair of the ad hoc commission, was also CC'd on it. I can resend it to you so that it can be circulated to the board if you'd like.
Sure. And yes, and I've also asked Louisa to look through our prior communication to the board, because as I said, I believe it was circulated to the board when we did receive it originally, but we can recirculate it as well.
Yeah, exactly, as well as a potential response. So well, in any event, certainly thank you for the continued communication on these important issues. I know that as Leah mentioned, there's been quite a bit of interaction with cable leadership, and we appreciate the partnership and the communication. All right, if I'm not mistaken, there are no further hands raised. I will give a last call here. And not seeing any raised. Is there any member of the board who wants to offer any comments or input? Mr. Tony.
If I may, I really appreciate listening to everybody who came and spoke today, gave public comment. And I want to encourage you that if you have anything in writing, either that you've sent before or that you'd like to send us after this, if you send it to Leah Wilson, our executive director, she'll make sure that all of us get a copy of it so that we can take a look at it and take it under consideration. I know that it's only a short time that you were able to testify today, and anything that you have in writing that elaborates your positions, I'd like to take a look at. Thank you.
I'm on mute. Thank you, Trustee Tony. I see Vice Chair Stallings has his hand raised.
All right, thank you, Mr. Chair. I just wanted to take an opportunity to thank each person who took time out of their day to really invest in the discipline system through your testimony and through your unique insight. I think that we've certainly gotten some valuable input today. We look forward to putting some of those ideas into action and examining them further. So thank you, everyone.
Thank you, Vice Chair Stallings. We did have another member of our staff join us after we convened, and I would like to introduce and say thank you to Ms. Aline Davtian, who is our relatively new General Counsel, for taking the time to join us at this hearing this morning. If there's nothing further, Ms. Wilson, Ms. Arepatian, Mr. Hernandez, I think we will adjourn, but let me just check with you. Okay, I think we're good. Thank you, everyone. We look forward to seeing many of you next week at our regular November meeting. Bye-bye.